The HOA president slid a lawsuit thread across my kitchen table. Smiling the whole time, she had no idea the judge had known my family for 25 years. If you love watching entitled HOA tyrants walk straight into their own downfall, subscribe now, because this one gets more satisfying with every scene. The HOA president slid a lawsuit thread across my kitchen table like it was a winning hand. She smiled the entire time. She had no idea the judge she was threatening to drag me in front of had known my family for 25 years. By the time that case reached the courtroom, she wasn't just losing. She was humiliated in front of the entire county. If you love watching entitled HOA tyrants walk straight into their own downfall, subscribe now, because this story ends with a judge who remembered exactly who I was, even if she never bothered to ask. I'd lived in that neighborhood my entire adult life. My parents built the house I grew up in 3 streets over from where I eventually bought my own place after they passed. The community had changed a lot over the years, new families moving in, an HOA forming about a decade ago that hadn't existed when I was a kid riding my bike down these same streets. I didn't mind the HOA at first. Reasonable rules, mostly about lawn maintenance and exterior paint colors, nothing that felt unreasonable for a quiet residential neighborhood. That changed the year Diane Pruitt became board president. Diane ran her position like she was auditioning for a courtroom drama. Every minor infraction became a formal violation notice. Every disagreement became a threatened legal escalation. Residents who'd lived there for decades suddenly found themselves fined for things nobody had ever mentioned before, things that had simply always existed without complaint until Diane decided otherwise. My issue started over something almost laughably small, a detached storage shed, built by my father nearly 15 years before the HOA even existed, sitting in the same spot it always had, completely unchanged since long before any covenant restrictions applied to my property. Diane decided that shed violated current setback requirements and demanded I remove it within 30 days or face daily fines escalating into legal action. I tried explaining the obvious. The shed predated the HOA entirely, grandfathered in under basic property law, protected by exactly the kind of legal precedent that exists specifically for situations like this. Diane wasn't interested in nuance. Rules are rules, she told me over the phone, her tone dripping with the kind of condescension that made my jaw tighten. I don't care how old the shed is. If you don't comply, I'll see you in court. I almost laughed at how confidently she said it, like the phrase itself was supposed to intimidate me into immediate compliance. Instead, it just made me curious about exactly how prepared she actually was to follow through on that threat. I called a family friend, someone who'd known my parents for decades, a retired paralegal named Frank who'd helped my father navigate several property disputes over the years. Grandfather clauses exist for exactly this reason, Frank said after I explained the situation. If that shed predates the HOA's formation and hasn't been substantially modified since, she doesn't have much of a legal leg to stand on. But that won't necessarily stop her from filing anyway. Some HOA presidents care more about looking powerful than actually understanding the law. Frank was right. Diane filed formal legal action 2 weeks later, requesting a court order demanding the shed's removal, along with retroactive fines for what she claimed was months of ongoing violation. I received the court summons on a Tuesday afternoon, listing a hearing date exactly 3 weeks out, along with the name of the judge assigned to preside over the case. I stared at that name for a long moment, feeling something shift in my chest that I hadn't expected. Judge Eleanor Whitmore. I knew that name. Not from legal proceedings, not from anything related to my current situation. I knew that name because Eleanor Whitmore had been my mother's closest friend for over 25 years, someone who'd sat at our kitchen table more times than I could count, someone who'd known me since I was barely old enough to walk. Diane Pruitt had no idea what she'd just done. I sat there holding that court summons, feeling a strange mixture of relief and genuine unease. Relief because I knew Eleanor Whitmore was fair, meticulous, and had absolutely no tolerance for baseless legal bullying. unease, because the last thing I wanted was for anyone to think I was somehow gaming the system by having a personal connection to the presiding judge. I called Frank immediately, explaining the situation. Does she still practice family law, or did she move to civil disputes? He asked. Civil disputes, from what I understand. She's been on the county bench for almost 8 years now. Then there's nothing improper here, Frank said. You didn't choose the judge. The court assigned her randomly, same as anyone else's case. If anything, this actually works against you making any kind of improper claim, since you'd need to disclose the relationship if it somehow became relevant. That last part gave me pause. Should I disclose it? Only if it directly affects the case's fairness, Frank said. Judges recuse themselves from cases involving direct financial interest or close personal relationships with involved parties. Knowing your family isn't the same as being biased toward you specifically in a property dispute, but it's smart to mention it to the court clerk beforehand, just so there's no appearance of impropriety later. I followed his advice, contacting the court clerk directly, explaining the personal connection between my family and Judge Whitmore. The clerk assured me this happened more often than people realized in smaller counties, and that unless the relationship was direct enough to create genuine bias concerns, cases proceeded normally. Diane, meanwhile, seemed entirely focused on building what she clearly believed was an airtight case. She sent me a follow-up letter through her attorney, listing photographs of my shed, measurements documenting the setback violation, and copies of the HOA's current covenant restrictions, highlighting the specific section she claimed I was violating. What she conveniently left out, whether through ignorance or deliberate omission, was any documentation addressing when those covenant restrictions had actually been established compared to when my father originally built that shed. I gathered my own evidence carefully, working with Frank to compile everything methodically, old property surveys from before the HOA's formation, clearly showing the shed's existing footprint. County records confirming the exact date the HOA's covenants were officially filed. A sworn statement from a neighbor who'd lived there even longer than I had, confirming the shed's presence decades before any HOA existed. 3 days before the hearing, I ran into Diane at the local grocery store of all places. She approached me with the same confident smile she always carried, like she'd already won before ever stepping into a courtroom. I hope you're prepared to comply, she said. I've done my research. This is a clear-cut case. I've done my research too, I said calmly. I think you're going to find this a lot less clear-cut than you're expecting. Her smile flickered slightly, just enough that I noticed, though she recovered quickly. We'll see what the judge thinks. We will, I said. She walked away without responding further, leaving me standing there with the distinct impression that she genuinely had no idea what kind of judge she was about to stand in front of. The morning of the hearing arrived with a nervous energy I hadn't quite expected, given how confident Frank's legal analysis had made me feel. I dressed carefully, organized my documentation one final time, and drove to the courthouse with my evidence folder sitting on the passenger seat like a shield I desperately hoped I wouldn't actually need. Diane arrived separately, her attorney beside her, both of them carrying thick folders of their own, moving with the confident stride of people who genuinely believe the law was firmly on their side. We were called into the courtroom almost exactly on schedule. I walked in, took my seat at the defendant's table, and watched as Judge Eleanor Whitmore entered from her chambers, robes settling around her as she took her seat at the bench. Her eyes swept the room briefly during introductions, cataloging both parties with practiced neutrality. Then her gaze landed directly on me, and for just a fraction of a second, brief enough that I doubt anyone else in that courtroom noticed, but long enough that I absolutely did, something flickered across her expression. Recognition. Judge Whitmore's expression settled back into practiced neutrality almost instantly, but that brief flicker of recognition sent a wave of relief through me that I hadn't expected to feel this early into the proceedings. She opened the case formally, reading the details aloud in a measured, professional tone that gave absolutely no indication of any personal connection whatsoever. Diane's attorney presented first, laying out their argument with confident precision. Your Honor, my client is seeking a court order requiring the defendant to remove an unpermitted structure violating current HOA setback covenants, along with retroactive fines for the duration of the violation. Judge Whitmore nodded, unreadable, flipping through the documentation provided. And when were these covenant restrictions officially established? Approximately 10 years ago, Your Honor, when the Homeowners Association was formally incorporated. And when was this structure originally built? Diane's attorney hesitated slightly. According to our records, the structure has existed for an undetermined period, but currently violates the setback requirement regardless of when it was constructed. Judge Whitmore raised an eyebrow slightly. Undetermined period? You filed a legal action demanding removal of a structure without establishing when it was actually built. The hesitation in the attorney's response was almost painful to watch. We believe the timeline is less relevant than the current violation itself, Your Honor. I'll be the judge of what's relevant, she said, not unkindly, but with enough firmness that the entire courtroom seemed to shift slightly in attention. Defendant, you may present your response. Frank had helped me prepare exactly for this moment. I stood, presenting my evidence methodically, starting with the property survey, clearly dated 18 years earlier, showing the shed's exact footprint in the same location it currently occupied. This survey was conducted 8 years before the HOA's covenants were even filed. I explained, my father built this structure well before any setback restrictions existed for this property. I followed with the county filing records confirming the HOA's official incorporation date, along with the sworn neighbor statement confirming decades of the shed's unchanged presence. Judge Whitmore reviewed each document carefully, occasionally making notes, her expression remaining professionally neutral throughout despite what I could only imagine was a slowly forming understanding of exactly how weak the HOA's case actually was. Counsel, she said, addressing Diane's attorney directly, are you familiar with the legal concept of grandfathered structures under covenant law? We are, Your Honor, but we believe, because based on the evidence presented, Judge Whitmore continued, this structure appears to predate your client's covenant restrictions by nearly a decade. Structures existing prior to covenant establishment are generally protected from retroactive enforcement, provided they haven't been substantially altered since. Diane, sitting beside her attorney, shifted uncomfortably, her earlier confidence visibly cracking for the first time since I'd known her. Your Honor, she interjected suddenly, apparently unable to stay silent any longer. Regardless of when it was built, it's currently an eyesore that violates community standards we've worked hard to establish. Judge Whitmore's gaze shifted toward her, cool and measured. Ms. Pruitt, community standards don't retroactively override established property law. If your association wishes to address structures built before your covenants existed, that requires a different legal process entirely, one involving proper compensation and mutual agreement, not unilateral fines and legal threats. The courtroom went quiet, the weight of that statement settling over everyone present. Diane's attorney whispered something to her, his expression tight, with the particular kind of frustration that comes from realizing your client has just undermined your entire argument in front of a judge. Judge Whitmore continued reviewing the documentation for another few minutes before finally looking up, addressing the room with the kind of clear, decisive tone that told everyone a ruling was coming. Based on the evidence presented today, she said, I'm prepared to issue my ruling. But before I do, I'd like to note something for the record. She paused, glancing briefly in my direction again, something unreadable but unmistakably deliberate in her expression. This court takes seriously any pattern of HOA leadership using legal action inappropriately against residents, particularly when documentation contradicts the claims being made. I'll be reviewing whether this case warrants referral for further examination of the association's broader enforcement practices. Diane's face went pale, because Judge Whitmore wasn't just about to rule against her. She was about to open the door to something far bigger than one shed dispute. Judge Whitmore's words hung in the courtroom air, and I watched Diane's composure crumble in real time, her earlier confidence completely gone, replaced by the specific kind of panic that comes from realizing a simple property dispute has just turned into something much larger. Ms. Pruitt, Judge Whitmore continued, this court is dismissing your petition in full. The structure in question predates your association's covenant restrictions by approximately 8 years and qualifies for protection under established grandfather clause precedent. No fines, retroactive or otherwise, will be assessed against the defendant. Diane's attorney leaned over, whispering something urgent, but Judge Whitmore wasn't finished. Additionally, she said, given the nature of this case, and specifically given counsel's own admission that the timeline of construction wasn't properly investigated before filing legal action, I'm ordering the Homeowners Association to cover the defendant's legal fees in full. I felt something loosen in my chest, relief flooding through me faster than I expected. But Judge Whitmore wasn't done yet. I'd also like to note for the record, she continued, that this is not the first case involving Ridgemont Hills HOA that has crossed my docket this year. The room went completely still. 2 months ago, she said, a similar case was dismissed involving a fence dispute where documentation showed the structure predated covenant restrictions by nearly 6 years. That case, too, involved retroactive fines pursued without proper historical verification. I glanced at Diane, watching her face shift from panic into something closer to genuine fear. Given this pattern, Judge Whitmore said, I'm formally referring this matter to the county's HOA Oversight Committee for review of Ridgemont Hills enforcement practices, specifically regarding whether proper due diligence is being conducted before legal action is pursued against residents. Diane's attorney stood immediately. Your Honor, with respect, my client's enforcement decisions aren't within this court's. They become within this court's purview. Judge Whitmore interrupted, her tone sharpening slightly when repeated pattern behavior results in residents being forced to defend themselves against baseless legal action, incurring legal fees and stress for violations that don't legally exist. That pattern is exactly what the Oversight Committee exists to examine. The courtroom remained silent as she gathered her notes, preparing to conclude the hearing. Before dismissing us, she looked directly at me. Not with any special warmth, nothing that would suggest impropriety, just the same measured neutrality she'd shown throughout. Case dismissed, she said simply. Court adjourned. I sat there for a moment after she left the bench, absorbing everything that had just happened. I'd walked into that courtroom expecting, at best, a straightforward dismissal based on the grandfather clause. I hadn't expected an Oversight Committee referral, or the revelation that Diane's aggressive enforcement pattern had already crossed this same judge's desk before. Diane gathered her things quickly, refusing to make eye contact with me as she left the courtroom, her attorney trailing behind her with the expression of someone already calculating how many more headaches this case was about to create for him professionally. I called Frank the moment I got outside, still processing everything. An Oversight Committee referral, he said, sounding genuinely impressed. That's not something judges do lightly. That means she's seen enough patterns of behavior from this HOA specifically to warrant real scrutiny. What happens now? The committee will likely request documentation on every legal action Ridgemont Hills has pursued over the past several years, Frank said. If they find a consistent pattern of pursuing fines and legal action without proper verification, that could result in serious consequences for the association, potentially even removal proceedings for board members who demonstrated a pattern of overreach. I drove home that afternoon, feeling the strange, quiet satisfaction that comes from watching someone's own aggressive overconfidence become the exact thing that exposed them. But I had no idea yet just how much that Oversight Committee was about to uncover, or how far Diane's pattern of behavior actually extended beyond just my shed and one dismissed fence case. 3 weeks later, I received a call that made it clear this story was far from over. 3 weeks after that hearing, I got a call from someone I'd never spoken to before, a woman named Patricia, who introduced herself as a member of the county's HOA Oversight Committee. We're conducting a formal review of Ridgemont Hills Homeowners Association's enforcement practices, she said. Your case, along with the fence dispute Judge Whitmore referenced, prompted us to request the association's complete enforcement history for the past 5 years. I wanted to give you the opportunity to provide any additional information relevant to the review. I told her everything: the initial threat over the phone, Diane's confident dismissal of the grandfather clause, her refusal to investigate the shed's actual construction date before filing legal action. Patricia took detailed notes throughout, occasionally asking clarifying questions that made it clear this wasn't just a routine formality. "I can't share specific details of an ongoing investigation," she said eventually, "but I'll tell you this much. Your case isn't an isolated incident. We're finding a consistent pattern here that goes back further than we initially expected." That single sentence sat with me for days, curiosity building steadily as I wondered exactly how extensive Diane's pattern of behavior actually was. I got my answer 2 months later, when the Oversight Committee's findings became part of public record, triggered by a formal complaint hearing scheduled specifically to address Ridgemont Hill's enforcement practices. The community clubhouse was packed for that hearing, residents filling every available seat. Word having spread quickly once people realized their own individual frustrations with Diane's aggressive enforcement style were actually part of something much larger. The committee's findings, read aloud during the hearing, painted a picture far more troubling than my own shed dispute or the previously dismissed fence case. Over the past 5 years, Ridgemont Hills had pursued formal legal action against residents in 14 separate cases. Of those 14, 9 had ultimately been dismissed or settled in the residents' favor, specifically due to inadequate verification of covenant timelines, structure histories, or existing legal protections that Diane's administration had simply failed to properly research before pursuing aggressive fines and threats. 9 out of 14. A pattern too consistent to dismiss as simple oversight or occasional mistakes. But the most damaging revelation came when the committee revealed something even Diane's own board members hadn't apparently known. Legal fees incurred by the association across those repeated failed cases had cost the HOA's community fund well over $40,000 in wasted litigation expenses, money that had come directly from resident dues, spent defending legal actions that should never have been filed in the first place. The room's reaction was immediate and visceral. Residents who'd quietly paid their dues for years, trusting that money was being used responsibly, suddenly understood exactly how much of their own contributions had been wasted on Diane's aggressive, poorly researched legal crusades. An older resident stood, voice shaking with barely controlled anger. $40,000? Fighting cases she kept losing because she wouldn't bother checking basic property history first. Another resident, someone who'd apparently been on the losing end of one of those 9 dismissed cases, stood as well. "I spent $3,000 in legal fees defending a fence that had been in the same spot since before I even bought my house. Nobody ever told me this had happened to other people too." The Oversight Committee's final recommendation, delivered near the end of that hearing, called for Diane's immediate removal from her position as board president, along with mandatory training requirements for any future HOA leadership regarding proper legal verification before pursuing enforcement action. The community vote that followed wasn't close. Diane was removed from her position that same evening, her name added to a county registry specifically tracking HOA leaders removed due to enforcement misconduct, a registry I hadn't even known existed until that hearing revealed its purpose. I sat there watching this unfold, thinking back to that overconfident smile she'd worn in the grocery store parking lot, so certain that a simple property line dispute would end exactly the way she wanted. Instead, one shed, one court date, and one judge who happened to remember exactly who I was, without ever once needing to say it out loud, had unraveled 5 years of quiet, expensive, poorly justified aggression against an entire community. Sometimes the people who threaten court the loudest are the ones who understand the law the least. And sometimes the truth doesn't need help to come out. It just needs someone patient enough to let the right questions finally get asked. If this story hit you the way it hit me telling it, make sure you're subscribed, because the next HOA story I bring you might expose something even bigger than a $40,000 mistake.